This module deals with the issues that can arise when one party alleges the parties agreed to modify an existing contract. Classical contract doctrine treated the modified agreement as a separate contract from the original agreement. To be enforceable, a modification required its own manifestation of mutual assent and consideration. The need for separate consideration often caused problems when a modification changed only one party's contractual obligations. For example, let's say a tailor was originally employed to work for a year for $90 a week, and then 6 months later, the tailor requested a raise and his employer agreed to pay him an extra $20 a week. That modification changed the employer's contract obligations. The employer used to be obligated to pay $90 a week and is now obligated to pay $110 a week. But the tailor's contractual obligations were not modified in any way. Under the original agreement, he was obligated to work, and under the modified agreement, he is still obligated to perform the same work. Under classical contract doctrine, the original consideration for the original agreement could not function as consideration for the modification. Consideration requires the promisee to do something he is not already legally obligated to do, and performing under an existing contract is a legal obligation. So in the hypo, because the tailor was already obligated to work for $90 a week, his promise to do the same work could not function as consideration for the employer's promise of an extra $20. This rule, that a modification required new consideration, was called the pre-existing duty rule, meaning that since the original consideration was a pre-existing duty, it did not qualify as consideration for the modification. Classical contract doctrine did recognize an exception to the pre-existing duty rule. The exception applied if the parties agreed to rescind the original contract and mutually release one another from their pre-existing contractual duties before they entered into the modified agreement. In that case, the rescinded contract's consideration would be freed up and available to serve as consideration for the new contract. This was called a novation. Sometimes the facts supported the notion that the parties intended to cancel the old contract and enter into a completely new and different contract. For example, the parties would tear up the existing written contract. But courts often found an implied novation even in the absence of supporting facts. That is, courts indulged in a legal fiction that there had been a novation whenever they wished to enforce a modification. This led to inconsistent results. See, for example, the Alaska Packers case in your casebook. Which rule does the trial court use? Which rule does the appellate court use? In response, both the UCC in Section 2-209 subsection 1 and the Second Restatement in Section 89 have jettisoned the requirement of consideration for contract modifications, at least under some circumstances. The UCC does this explicitly. Section 2-209 subsection 1 reads in its entirety, "An agreement modifying a contract within this article needs no consideration to be binding." The UCC still allows courts to police modifications, however, but this is now done under the rubric of Section 1-304, which imposes a duty of good faith on the performance and enforcement of every contract within the scope of the UCC. So if a court determines that a modification is made in bad faith, for example, one side uses its superior bargaining power to intimidate the other into agreeing into a modification without any other justification, it can refuse to enforce the modification. The restatement section is less explicit and all-encompassing than the UCC rule, but the result is often the same. Consideration is not required for a modification to be binding. Section 89 is less broad because it limits its application to executory promises, that is, promises under a contract that are not fully performed on either side. Under Section 89, modifications in executory contracts are binding if one of the three requirements are met. 1. The modification is fair and equitable under the circumstances. 2. A statute provides such a modification is binding. Or 3. There has been a change of position in justifiable reliance on the modification. The changes in the Second Restatement do not mean that the old classical contract doctrines have been overruled, however. A recent case from the Seventh Circuit, after concluding that a modification was made in good faith, nevertheless refused to uphold the modification on the basis of the pre-existing duty rule, that is, on the basis that there was no consideration for the modification. Under both the UCC and second restatement, all of the typical contract defenses such as duress, undue influence, etc. are available against modifications. And in any case where a party could show that they entered into a modification under one of the defenses, it seems pretty clear that a court could refuse to enforce the modification under either the defense or under the good faith rule, as any circumstances that gave rise to one of the defenses would also certainly constitute bad faith. But theoretically at least, a court could find a party acted in bad faith even in situations that are not covered by the typical contract defenses. Oral modifications can present additional issues. Recall that the parole evidence rule does not apply to modifications. It only applies to prior or contemporaneous extrinsic evidence. But does the statute of frauds apply to modifications? The answer is maybe. UCC section 2-209 subsection 3 provides that a modification must satisfy the statute if the contract as modified is for the sale of goods above the statutory amount, $5,000 under the current revision. For example, suppose the original contract was for less than $5,000 worth of goods, and the modification adds more goods to the order so that the modified contract is for more than $5,000. In that case, the modified contract must satisfy the statute of frauds, even though the original contract did not have to satisfy the statute. Many courts have held that this provision also bars oral modifications of written agreements that are within the statute. Outside of the UCC, many courts hold that any material modification of a written agreement within the statute must also be in writing. Moreover, parties to a written contract may attempt to create a private statute of frauds by contractually providing that any modification must be in writing. These are sometimes called NOM clauses, for no oral modification. Under the common law, such clauses were usually held invalid, thus allowing oral modifications. UCC section 2-209 subsection 2 attempts to change this by explicitly providing that such clauses are valid, thus prohibiting oral modifications. However, in section 2-209 subsection 4, the UCC also provides that an unenforceable oral modification might instead be enforceable as a waiver.